Matter. Mr. Simpson is again present with his counsel, Mr. Shapiro, Mr. Cochran, Mr. Blazier, Mr. Scheck, Mr. Neufeld, people represented by Mr. Darden and Mr. Clarke. Jury is not present. I assume there are a few things we need to discuss before we resume with the jury.
Yes, Your Honor. With regard to the remaining area with Dr. Cotton.
All right. Good morning, Mr. Clarke.
Good morning, Your Honor. Dr. Cotton has spent overnight actually toiling at very late hours in preparation of these population frequencies that the court has requested. It's my opinion that she is not prepared at this time to present those with the type of preparation that is necessary. It is our intent to call another witness to describe the frequencies with these mixtures, in which we will comply with the court's direction. We will provide frequencies for these numbers. It's our intent not to do it at this time.
Who is this other witness?
Dr. Bruce Weir.
He's okay. When do you anticipate Dr. Weir being available?
He will be available, and what it is our intent to do with Dr. Weir is to have him discuss, obviously not just these frequencies as to these particular two mixtures, but also other frequencies in the case as well. So what we will await for his testimony is a description of the results in this case, and then to conclude that in terms of once frequencies are discussed or described by the witnesses who are yet to be presented, he will then present testimony about those calculations.
All right, so you anticipate, under your proposal, we finish with Dr. Cotton this morning, move on to the California Department of Justice. Are we going to get any other lab results from any other lab?
The Los Angeles Police Department.
And then somewhere in this mix, you're going to have Dr. Weir.
Correct.
All right. Mr. Neufeld.
Sir, Your Honor.
Good morning.
Good morning. As you may recall, you issued a ruling in this case stating that DNA results of a match or of a consistency could not be presented without some number. Although you said that you don't, every time you use the word match, you don't have to, at that point, articulate a number. With respect to Dr. Cotton, you issued a ruling saying that at some point during her testimony, she had to provide these aggregated frequencies for the mixtures pursuant to the NRC position.
I don't think that's quite what I said. But go ahead.
All right. In any event,
we were talking in terms of mixtures, not specifically in terms of Dr. Cotton's testimony.
I think we were talking in terms of both, Your Honor.
All right.
Both mixtures and Dr. Cotton's testimony. In any event, she did apparently produce numbers. The numbers were given to us this morning. The suggestion, at least in the pieces of paper that I've received, is that they concur with our numbers on the steering wheel item 29. Is that just from the paper that they presented to us? And then they calculated different numbers for item number 78 applying three different assumptions. I believe that under the court's ruling, I didn't go into this on cross-examination because it was an understanding that we had at the bench, the sidebar, that Mr. Clarke would be allowed to reopen his direct testimony to introduce their numbers for these mixtures through Dr. Cotton. If they don't intend to do so now, and the court is going to allow them not to do that now, then I have an absolute right, Your Honor, to reopen my cross-examination as to these two limited issues and ask her questions about frequencies pertaining to item 78 and frequencies pertaining to item 29. I have a right to do that with this jury while this witness is still here, and this jury is assessing the totality of this witness's testimony. I gave up that right to do that as part of my cross because I was under the impression, based on the court's ruling, that I would have an opportunity to do that through this witness once they reopen their direct. And even if you're going to allow them to postpone their presentation, then certainly, since genotype frequencies were brought out for lots of different items on direct examination, I should be entitled to cross-examine her now based on the frequencies for 29 and 78.
All right. Any response, Mr. Clarke?
Just that I think that under those circumstances, that testimony, that is cross-examination testimony, would clearly be beyond the scope of direct examination. I don't think there's any requirement that we elicit a particular fact from a particular witness when we're going to comply with the court's order.
All right. Okay. All right, well, the court's ruling in this matter was in concurrence with the NRC report that frequencies with regards to mixed stains, there had to be some report of some number, some statistical importance attached to that conclusion. The defense did withhold any cross-examination as to that issue. However, there's nothing within the scope of the direct examination that can be cross-examined at this point with regards to frequencies on the mixtures. Mr. Neufeld, I'm not preventing you from questioning Dr. Cotton as to those issues. If you want to call Dr. Cotton in your case in chief during your defense, you're entitled to do so if you want to question those frequencies. You asked me to make this ruling to require the prosecution to provide the statistical information. They have chosen not to present that at this time. They've indicated they have another witness that they're going to use to present that information. They're entitled to present their case in the manner in which they wish to.
Your Honor, there's 2 points that need to be made at this point, if I'm... Oh, I'm sorry.
Nope, that was the end of the argument. Next item. Next item.
Well, Your Honor? Well,
That was the end of the argument.
Good morning, Your Honor.
Good morning, Mr. Cochran.
Your Honor, in this matter, I wanted to just point out a matter to the court in our ever ongoing attempt to keep the court abreast of things that are happening. In driving around the city recently, Your Honor, I've seen these billboards. I've seen only the ones that say guilty, which is troubling to me, but I understand there are also some that say innocent. I'm not sure who put up these billboards, whether it's some kind of a promotion or some kind of a movie or whatever. But I wanted to point it out to the court because I'm concerned that as our jury goes on these outings, the court was aware that there was somebody shout out something at a Laker game when the jury was there, and I just wanted the court to be aware of that so that if and when the jury is taken out on outings, we need to know about this so they're taking down routes that have signs saying one thing or the other that could be prejudicial to either side of this case. And I thought it would be incumbent upon me to bring this out to the court's attention at this point. The other thing I wanted to point out to the court was we do have a number of matters which have kind of slipped off our plate, as it were, and I would like at the appropriate time for counsel on both sides to meet with the court to try and get some of these things rescheduled. I know we've been very busy, and it's good to have the evidence moving along, but there are some other matters we need to deal with at some point.
I think what I'll do is have Mrs. Robertson make up another list of the items that are yet to be resolved, and we'll start with that, and then we'll schedule a meeting amongst principal counsel for both sides to schedule resolving those issues. Unfortunately, we just had the autopsy coroner's report hearing changed to the afternoon of the 19th, which would have been an ideal time.
Yes. All right.
And I anticipate, since we're talking about 50 photos and some significant legal and medical issues on that, I anticipate probably having to spend the whole afternoon with that motion.
Probably so, Your Honor. We'll be available, Your Honor. Thank you very
Okay.
much.
All right, then, Mrs. Robertson, would you advise Sergeant Smith? I'd like to speak with him regarding outings. All right. Anything else before we conclude, Dr. Cotton?
I was just proposing to Mr. Cochran that perhaps we can discuss some of these matters that we have pending before the court, that some of those motions perhaps can be resolved between counsel without need to take up the court's time, and if that's possible, we will do that. I wanted to indicate to the court that I have seen those billboards. The ones I saw were innocent, and I mean, I wonder, there's something otherworldly about this, but I kind of thought it was a promo for something else. I'm hopeful that that's the case in any case, but if there's any possibility of making sure that the bailiffs look at the route that would be taken by the jurors wherever they're going to make sure they see neither of those billboards.
No, my instructions and the Sheriff's Department precautions always include a survey of the route to and from before. But I just want to make, that's why I asked Mrs. Robertson to contact Sergeant Smith for me. I just want to make sure that we both understand that that's still the policy. That has been the policy, but I'm
That's good.
just to give Sergeant
Okay,
Smith a
thank
heads up to avoid those things.
Thank you, and we will try to resolve some of these matters.
One last
Right.
matter then.
Yes,
You
Mr.
said
Neufeld.
before the conclusion of Robin Cotton. In light of the court's ruling, I would ask the court to strike the testimony of Robin Cotton with respect to the mixture on item 78 I think that, as you may recall, there were several times during my cross-examination of Dr. Cotton where I tried to introduce certain facts subject to connection, and the court said that wasn't appropriate and said that if I want to do it during my case, I can go right ahead and do so. I think that out of fairness, Your Honor, the same result and the same approach is warranted here. You had ruled that evidence of mixtures or matches would not be permitted.
Counsel, you're re-arguing the issue.
No, I'm not, Your Honor. I'm simply saying I'm asking for you to strike that portion of the testimony. I'm not talking about my right to cross-examine her on this point at this time. I'm simply asking that since the court has taken the tack that it's taken, that the appropriate relief is, with respect to item 78, that should be stricken from the record at this point until such time as they produce a number.
First you want me to make a ruling requiring the prosecution to present the evidence in a certain manner. I grant that. They decide in light of that they have to adjust their case. So you can't have it both ways.
I don't think I'm asking
All
you
right.
both ways, Your Honor.
Mr. Clarke, any response? All right, motion's denied. All right, let's have the jurors.
Where are we left off with Dr. Cotton in terms of questioning? I think she may be concluded. Yes, Mr. Harmon does.
All right. Let the record reflect that we've been now rejoined by all the members of our jury panel. Good morning, ladies and gentlemen. All right, as to Dr. Cotton, she is again present in the courtroom. Both sides have concluded recross and redirect. Mr. Clarke, Mr. Neufeld, in light of the court's rulings, any further questions of Dr. Cotton?
Not on behalf of the people, Your Honor.
And of course, rulings, there's no further questions by the defense at this time, Your Honor.
All right. Then, Dr. Cotton, you are excused subject to recall. All right, thank you, ma'am. All right, people may call the next witness. All right, good morning, Mr. Harmon. Are you going to be handling the next witness?
May I introduce myself to the jury?
Yes, you may.
Good morning, ladies and gentlemen. My name's Rockne Harmon. I'll be handling the next few witnesses. Prosecution calls Gary Sims.
All right, Mr. Sims, would you come forward, please?
I solemnly swear that the testimony you may give in the cause now pending before this court shall be the truth, the whole truth, and nothing but the truth, so help you God. Please have a seat in the witness stand. You state and spell your first and last names for the record.
My name is Gary Sims, G-A-R-Y-S-I-M-S.
Mr. Harmon.
Thank you, Your Honor. Mr. Sims, who do you work for?
I work for the California Department of Justice in their DNA laboratory in Berkeley.
Could you describe the relationship of your laboratory within the state administrative system?
Yes, we're part of the Department of Justice, and we are within the Bureau of Forensic Services, and specifically the DNA laboratory serves the entire state. Our particular jurisdiction is generally those areas that are not covered by a lot of the major cities and that sort of thing. And so we have regional laboratories located throughout California, and they generally feed cases into us.
Now, what's the relationship of the Department of Justice to the State Attorney General?
We are under the Office of the Attorney General.
And does the Department of Justice have many different branches other than the Bureau of Forensic Services?
Yes, it does.
What are those other branches?
There's several divisions, such as the Division of Law Enforcement. There's other divisions that include the attorneys, state attorney, deputy attorney generals, that sort of thing.
And other than the DNA laboratory, could you give us an idea of what the Bureau of Forensic Services provides statewide?
Yes. They provide forensic criminalistic services to a number of jurisdictions, a number of different law enforcement agencies throughout the state. As I mentioned earlier, in California, most of the major cities and counties have their own crime laboratories, but we provide services to some of the what used to be more rural areas of California, but we also make our services available to other counties, the larger counties also.
Now, other than, you have one DNA laboratory, is that right?
That's correct.
Other than the DNA laboratory, are there other laboratories under the Bureau throughout the state?
Yes, there are.
Could you give us an idea of how many and where they are?
Yes, there are laboratories located in places such as Riverside, Fresno, Sacramento, Redding, Santa Rosa, Santa Barbara.
Okay. Now, how long has the DNA laboratory been in place?
The DNA laboratory for the state DNA laboratory was established in late 1989, so a little over 5 years now.
And has it always been in Berkeley?
Yes, it has.
Were you one of the original employees?
I was not one of the original, but I was one of the early group, yes. The earliest people were hired in late 1989. I came on board in January 1990.
Could you please explain to the jury the types of services the DNA laboratory provides to the citizens of this state?
Yes. We analyze biological evidence. Generally, the types of cases we work on are homicides or also sexual assault cases. And the types of evidence that we analyze using DNA technology would generally involve blood, semen, hair, other bodily fluids.
Okay, now, would we call that casework services?
Yes, that's our principal casework service. We also are in charge of the felon offender database, whereby DNA or blood samples are collected from felons upon release from prison, and then we type those samples for the DNA profile, and we feed those into the database so that we have an ongoing bank of felon offender data files.
And how long has the database or that bank been in place?
The plans for it have been in place for a number of years. We recently, well, not recently, it's been about, I think, about 3 years now that we've been putting those sample profiles together.
And so the goal is to have known offenders in this database in case... What's the goal of this database with respect to known offenders?
The goal of this is so that when we have, for example, a sexual assault case where we don't know, we don't have somebody arrested to check their DNA profile on, we can go into this database and see if whether or not that DNA profile that we might obtain from, for example, a semen sample on a vaginal swab, whether or not that profile is in our database, and that may provide information that we may have the perpetrator through the DNA.
Now, do other states have a similar database set up?
Overruled.
Yes, this is a nationwide effort.
All right, let's move on.
Thank you, Your Honor. Are the same technologies that were used in this case used in the database?
Yes.
But are they done by different people?
Yes, we have a different part of our laboratory that does what we call it's a 290 is the statute on that, so we call that the 290 program.
Okay, Mr. Sims, let's talk about you and your background for a little while, okay?
Okay.
Starting with your undergraduate education, could you please describe where you obtained it and what your degree was in?
Yes, I obtained a Bachelor of Science degree in criminalistics from the University of California at Berkeley, and that was in 1975.
Okay, and did you attain any honors at UC Berkeley?
Yes, I did.
And what were they?
I graduated Phi Beta Kappa.
Could you explain what that means?
Well, Phi Beta Kappa is an honor society that recognizes a certain percentage of the graduates. I don't know the exact formula, but it's considered an academic honor.
Okay, and did you pursue any graduate studies after that in criminalistics?
Yes, I did. I pursued graduate studies in criminalistics also at University of California at Berkeley, and I did that from 1975 to 1976. And then also I worked on a graduate program at California State University, Los Angeles from 1978 to 80.
Okay, in the graduate program at UC Berkeley in 75 and 76, did you attain any honors in that program?
Yes, I was studying under a Regents Fellowship.
Okay, what other specialized courses have you taken over the years that lend to your credentials for forensic DNA typing?
Yes, among the specialized classes that I've taken, for one thing, I've gone back to school with the advent of DNA technology into forensic science. So I went back to school and took classes in recombinant DNA technology through University of California Extension, and also classes in molecular biology through the Extension, and I also took a class in genetics from California State University at Hayward, so that I could be brought up to date with the DNA technology.
What years did you take those classes?
That would be from 1990 through 91.
Okay, and subsequent to that, did you have some training in Virginia?
Well, actually, the Virginia training is twofold. There was a class that I took that is offered through the Federal Bureau of Investigation at their research center in Quantico, Virginia, and that was a one-month class in forensic DNA typing, and that is actually credited, along with the laboratory portion, that is credited through the University of Virginia.
And did you take another class in the same setting?
Yes, I did. I went back 2 years later to take an advanced class in 1992. That was a one-week class.
Okay, and also did you take a forensic DNA class at UC Berkeley?
Yes, that was offered through the Extension, and a lot of the criminalists in the Bay Area attended that class. It was about DNA technology. The class was taught by Dale Dykes, and also the PCR portion was taught by Dr. Blake, and then also by Dr. Cecilia von Beroldingen.
And
How do you spell that?
Von, and then Beroldingen, I think.
That's right. Okay, now, these are all formal classes and courses that you've taken over the years. Are there other ways that people in your field keep abreast of things and further their intellectual and education?
Yes, we do that by attending specialized classes that are designed for people in our field, and they're typically, sometimes they're a one-day seminar, sometimes they're a week, something like that, and I've taken a number of those.
And are they frequently taught by prominent people in their respective fields?
Yes, they are.
Could you tell us what kinds of classes or sessions fall into that category, please?
Yes. One of the most recent ones was in 1992, a one-week class taught in population genetics and statistics by Dr. Bruce Weir. That was put on by the California Association of Criminalists, and that was 1 week, as I mentioned. I've also took a one-week class that was offered by the Cetus Corporation. They're the company that in which PCR was developed. They held the patent on the PCR. And that was in the use of doing PCR DQ alpha typing in forensic work.
All right, and Mr. Harmon, Mr. Sims, I think the record should reflect that the witness is referring to a CV.
Yes.
Yes,
You're referring to your CV.
Yes, there's a lot of dates on here that I,
Kind of hard to remember all of them?
yes.
Okay, why don't you tell us about the next one?
I've also attended, for example, in DNA, a non-isotopic detection class that was offered by Allotype Genetic Testing Services down in Atlanta, Georgia. That was taught by Dr. Moses Shanfield and also by Dale Dykes. That was actually that was my first formal coursework in, first formal class in DNA procedures, and that was in 1988. I've also taken various workshops, such as workshops in statistics, blood spatter, that sort of thing. I've also taken a 3-week class in conventional forensic serology, such as the EAP marker that I think you've heard some things about. That was in 1979, and that was a 3-week class.
Okay, and over the years, have you been recognized or been awarded certificates in areas of expertise in your field?
Yes.
Could you tell us what those are?
Yes, most recently I obtained a certificate of professional competency in criminalistics from the American Board of Criminalistics, and that was in 1993.
Could you tell us a little bit about that program and how it was, what it reflects?
Yes. Well, what this program reflects is a nationwide effort to enhance the professionalism of criminalistics is what it's all about. And what it involves is taking examinations in certain areas to show that you're competent, and it also now will involve proficiency testing and that sort of thing. So it's to raise the professionalism.
Now, is that something that recently came about, that program?
Well, California took an early lead in this in the late 1980s. There was the program was offered through the California Association of Criminalists, and I first obtained my certificate in 1990 from the California Association of Criminalists, and then this program has now gone nationwide.
Okay. Now, you've used the word criminalistics. Could we broaden that definition and explain what's entailed, let's say, in that certificate? What kinds of things did that certification process cover?
What the certification program in criminalistics entails is the various aspects of physical evidence examination, and that would include the collection of evidence, the analysis of evidence, the interpretation of evidence.
What sorts of evidence?
Various kinds of evidence. For example, biological evidence, trace evidence, firearms evidence, all the different disciplines within criminalistics.
Did you necessarily feel much more qualified simply because they gave you the certificate than you did before you obtained it?
No, but I think that kind of program is valuable in that you have to have a certain level of knowledge to pass the exam.
Okay. Are you a member of the California Association of Criminalists?
Yes, I've been a member since the late 1970s.
Please describe the nature of your employment in the field of criminalistics from the first job in this area.
Yes. My career began in 1976, about almost 19 years ago now, in June of 1976 with the Department of Chief Medical Examiner Coroner here in Los Angeles, where I worked in the laboratory. I performed toxicological and serological examinations at that time. Some of that would be blood alcohol testing, that sort of thing, but also doing blood typing, examination of sexual assault evidence.
Conventional serology?
Conventional serology, yes.
Okay.
And I worked at the coroner's office for 3 years, and then in 1979, I went to work at the Los Angeles County Sheriff's Department in their crime laboratory, where I worked in the serology program, again doing what we've termed conventional serology. And after a little over a year in that, I took an opportunity to go work at the Institute of Forensic Sciences Criminalistics Laboratory, which is a private crime laboratory in Oakland, California, under the directorship of Charles Morton.
Chuck Morton?
Chuck Morton, yes.
What sort of clientele did you have there?
Well, since we were a private concern, we did work for both prosecution agencies, police agencies, but most of our work was for defense attorneys.
Did that cause you any personal problems?
No.
Philosophical problems?
No, as a criminalist, I approach the evidence. I don't care which side it's coming from. My concern is with the evidence and the examination of the evidence.
In the course of those years, did you ever testify for a defendant?
Very often.
Do you ever contradict any prosecution evidence?
Yes, I did.
How frequently?
Occasionally. Sometimes when you're doing this kind of reanalysis, this defense reanalysis, you may, for example, have a situation where you out and out disagree with the result, and then you have to be able to go in and defend that. But also, you have situations where there's other types of evidence that perhaps the prosecution has not looked at, and then you might examine that evidence and say, this is what my findings are, and they're really not contradictory to other findings.
Now, in that context, you mentioned that you reanalyze things. Is that right?
Yes,
So physical evidence was made available to you to reanalyze and evaluate?
yes, that was a very common part of our practice.
And what year did you move on from there to the Department of Justice?
I worked at the Institute of Forensic Sciences from 1980 to 1990, and then it was in early 1990 that I went to work at the Department of Justice.
Okay, would you describe the nature of your initial responsibilities at the Department of Justice?
Yes, our initial responsibilities were twofold. One, we had to set up the laboratory because all we had was a building, a room in a building, and we were working through Lawrence Berkeley Laboratory. We had sublet space within their facility up in Berkeley. And so we obtained the equipment, and then the next portion was to go through the training and what we call in-house validation procedures, to take validated procedures and put them online in our own laboratory. And that went on for about 2 years until we actually started doing any casework.
Okay, what was your specific role during that time period?
My specific role was to take part in some of these research projects and to get trained in these other areas.
Okay, now, at the time the DOJ began, were there other laboratories around the country and the world that were already providing forensic DNA services?
Yes, there were.
Can you recall which ones those might be?
Well, for example, the FBI went online with DNA, and I believe in late 1988, Cellmark was online before that time, Life Codes, and then some of the other state laboratories, I believe Virginia was online before that too, but I don't know those exact dates.
Okay, please describe the next phase of the implementation and what your specific role was.
Well, the next phase was then to prepare myself to actually do casework, and so we went through proficiency tests, that sort of thing, mock evidence samples, and then once we had shown that we could handle that type of evidence and get the correct results, then we actually started accepting cases, and I was one of the first caseworkers.
How many other caseworkers were involved at that point in time?
One other.
Okay. What took so long if these other labs were already providing the services?
Other people have asked me that same question. The approach that we took was to, first of all, we wanted some experience with the techniques, and that does take some time. We didn't want to rush into this. We didn't want to make a rush to just get online for the sake of going online. We wanted to feel confident in our abilities to analyze this evidence. And also, some of the types of research studies that we did involved trying to make what starts out, for example, as a good blood stain, a bad blood stain. In other words, to see what can happen to various types of forensic evidence, so that you're just not dealing with fresh samples. You're looking at samples that may have been degraded, for example, and seeing what you can do and what happens when you challenge those types of samples with various environmental conditions. And that was one of our big experiments that took a long time.
Now, had other people already done these kinds of experiments?
Yes.
And why did you feel the need to do them yourselves?
Well, at that time, some of the studies weren't all published. So this is, you have to remember that some of these plans were laid down in 1990, and then some of the publications that came along would be maybe 91, 92, but there was not a lot of published information at that time. But also, I think it's important for somebody who's going to look at this type of evidence to get an appreciation for what can really go wrong with this type of evidence and why you have to be concerned about degradation and those sorts of things.
And so when was it that you actually accepted your first case in this state?
It was, I believe it was either May or June of 1992.
We'll get back to your experience at DOJ in a moment. Have you yourself made presentations at some of these scientific symposia over the course of your career?
Yes, I have.
And typically, are there co-presenters or co-authors of some of these papers or presentations?
Yes, in our laboratory, most of the presentations involve a team approach, and usually one person then becomes the speaker.
Okay. Could you please go through the presentations you've made?
Yes, I'm going through my CV to review this. My most recent presentation was regarding some casework analysis that I did. This was presented in 1993 to the California Association of Criminalists at their seminar, and they have a seminar twice a year where criminalists get together and exchange ideas. So this was just a part of that, and this was specifically at now what we call the Western Region DNA Laboratories Workshop, where the field has gotten somewhat more specialized, and so the DNA people all huddle together in a room for a day and talk about DNA. Another presentation that I did was at the Second International Symposium on Forensic Aspects of DNA Analysis that was hosted by the FBI Academy, and this was in March of 1993. I presented a poster regarding concordance of our results between laboratories contributing to the DNA data bank that I mentioned. And what that basically involved was having different laboratories in the state, such as Orange County, San Bernardino, and our laboratory, being able to show that we could exchange our data and that it could all go into the same data bank for this profile offender.
Okay, so you could use other people's data that had a compatible system with you?
Yes, yes.
Okay. We'll come back to that in a while.
Okay.
What was the next presentation?
The next presentation was a study that I did with Alan Keel at the, and also Martin Buon Cristiani from our laboratory at the, it was presented at a statewide criminalist, Department of Justice criminalist convention, or it's called the STEP conference, and that was in 1991. And we did a study whereby we took actual sexual assault evidence and compared our results with the results of an analyst at the Oakland Police Department.
Okay, and the next presentation?
The next presentation that I gave was one where we did fairly early on in 1990, the recovery of, and we extracted DNA from bone samples that had been very badly burned to show that you could still do typing on this kind of sample. This was presented at the California Association of Criminalists meeting in Long Beach in October 1990, and then it was also presented by Jennifer Mihalovich at the American Academy of Forensic Sciences meeting in February 1991.
Who were your other colleagues on this collaborative effort?
On that particular presentation from our laboratory, myself, Lance Gima, Ken Konzak, and then the other authors on the paper or the presentation were Jennifer Mihalovich and Dr. Edward Blake from Forensic Science Associates.
And is Jennifer Mihalovich with Forensic Science Associates as well?
Yes, she is. Yes, she is.
Now, this Dr. Blake, has he also made presentations at your laboratory, educational type presentations in the field of PCR typing?
Yes.
And have I also made presentations at the same time?
Yes, you've lectured us on the legal aspects.
Okay. How frequently has this Dr. Blake made these kinds of presentations at your laboratory?
Once or twice a year.
What would be the next presentation then in the order after the Jennifer Mihalovich at the American Academy of Forensic Sciences?
I've given a lecture on DNA typing to the California District Attorneys Association. That was in 1990. And then also in 1990, I gave a talk at the California Association of Criminalists on the role of the special master for the serological evidence in the case of People versus Richard Ramirez.
At the Night Stalker case?
Yes, that was the Night Stalker case, and our laboratory, Institute of Forensic Sciences, was assigned the role under Judge Tynan, I believe it was, to act as a special master, which meant that we were in control of the serological evidence, and we would bring it to the defense laboratory and let them reanalyze it while it was still under our care. So we were responsible for taking evidence from LAPD, getting it over to the defense laboratory, and monitoring their testing. Not that we would record what they're doing, but just to keep an eye on the evidence, basically to ensure the safety of the evidence.
And Have you ever performed that role in any other case
Yes, I believe I have.
where you monitored defense testing of physical evidence?
Yes.
What other contributions have you made, either in presentations or in publications?
I've also contributed to, in our seminars among the California Association of Criminalists, I've gone before the CAC and talked, or California Association of Criminalists, and talked about what I thought was, for example, questionable testimony regarding sexual assault evidence and hair examinations. Those are things that I saw as a defense expert that I thought needed to be brought out that I was not pleased with.
And the next presentation?
The next presentation was one on the value of defense reanalysis in forensic serology. That was given at a medical legal seminar sponsored by the Institute of Forensic Sciences in May 1987. And
Was that based on your years of experience of reanalyzing physical evidence for defendants in criminal cases?
yes, and what I did is I showed what I thought were the value of certain illustrative cases where doing the defense analysis proved to be very useful, provided useful information.
And the next presentation?
I've presented aspects of physical evidence to the criminal defense panel of the Sacramento County Bar Association. That was in 1985. And I've also given talks on paternity resolution with using conventional serology. That was a medical legal seminar in May of 1985. And I've also given a lecture on problems observed in the comparative analysis of human and animal blood stains. And again, that was a medical legal seminar, Institute of Forensic Sciences, back in 1984.
Okay, and then the next category is co-presentations, where you co-presented papers. Could you describe those in order, please?
Yes, this next series are papers where I've just been one of the authors, or I've been on the group of people that actually did the paper, but I wasn't the one who actually presented it. The first one is the application and evaluation of D1S80 for casework analysis. That was presented by Renee Montgomery at the California Association of Criminalists seminar in May 1994.
And D1S80 is one of the markers that we'll be talking about, the DNA markers that
Yes, it's a PCR marker like DQ alpha or this polymarker.
it was used in this case.
It was used in this case.
Okay, what was the next presentation?
This was a paper presented at the Second International Symposium hosted by the FBI Academy in March 1993. The title was Penile Swab Evidence in the Investigation of Sexual Assault. The actual presenter was Alan Keel. This was a poster presentation, and what we did in that case was to look at some swabs that had been taken from the penis of a rape suspect, and look at that using PCR markers to see if we could get information about the victim's type transferring to the male.
And in those instances, that research demonstrated with that kind of physical contact, you could find the trace of the female's DNA on the assailant's penis?
Yes.
What was the next presentation?
The next presentation was, this was actually presented by Dr. Nora Rudin of our laboratory in February 1992 at the American Academy, and this was the environmental abuse sample or abuse study that I mentioned earlier, where we took a large number of blood and semen samples, subjected them to things like ultraviolet light, heat, humidity, looked at various substrates and see what the effect would be, and then we presented that work at this American Academy meeting. And then the next one was another American Academy meeting. This was actually presented by Keith Inman of our laboratory in February 1992, involving establishing the matching guideline within the California Department of Justice laboratory. And that was basically to establish how our laboratory went about saying when do two bands match, that you heard some talk about earlier.
Okay, and the next presentation?
The next presentation was a poster presentation involving it was presented at the American Academy of Forensic Sciences in 1992. It was entitled DNA Electrophoresis Tank Evaluation, and this was basically one to evaluate which equipment would be best for our needs, which equipment gave us the best results. And we looked very seriously at the different types of apparatus available to perform these electrophoretic gel separations, and we evaluated that and presented our results.
And then the prior co-presentation, please?
The last one goes way back to May 1977. This was regarding a toxicological presentation about barbiturates in radioimmunoassay screening and postmortem samples. This was done by Ron Bergeson, who was, and along with George Nakamura, who were at the coroner's office, and this was back in 1977.
Okay. And as part of your role in the forensic community, do you frequently teach?
Yes, I've been asked to teach.
Okay, could you please describe the courses or teaching classes that you've been a teacher in?
Yes. The experiences that I've had are generally through the California Criminalistics Institute, which is a research group as part of the Department of Justice Bureau of Forensic Services. One of their principal missions is to train criminalists from throughout the state. And I've taught classes involving the investigation of sexual assault, what you do with sexual assault evidence, that sort of thing. I've also taught classes in conventional serology at the California Criminalistics Institute.
Okay, and what other teaching experiences have you had?
I've also taught at this level in the PCR DQ alpha procedures. I've lectured in that.
Could you be more specific than that?
Yes, some of these classes are now offered. This PCR DQ alpha class is actually offered through the Department of Justice, through the California Criminalistics Institute, and I have taught at that. I've also taught in the area, or not actually taught, but I've participated in workshop discussions in classes put on by Roche Molecular Systems. They're the ones that offer these PCR kits, such as the DQ alpha and polymarker kit, and I've been invited to speak at their classes to people who are now learning the technology, and I'm exchanging some of the experiences that I've had with the kits.
And what other teaching experiences have you had?
The final one is with regards to the Forensic Academy. Again, this is part of the training of new forensic scientists.
And that's under the auspices of the Department of Justice again?
Yes, it is.
Do you belong to any professional organizations?
Yes, I do.
And I'll ask you to describe them, and if you're members of any specific committees or panels, could you please describe them when you describe the organization you belong to?
Yes.
Go ahead.
The first one, as I mentioned earlier, is the California Association of Criminalists. This is it's getting to be a very old body now. It goes back into the 50s. I think about the time I was born is when it was established. But it's got a large number of members who practice criminalistics, not only in California, but we have members from various states. I was a member of the Board of Examiners within the California Association of Criminalists, and that was, I talked about how we put together this test in certification, and I was involved in that process. I was also a member of the Quality Assurance Committee for Forensic Serology. That's conventional serology, and that goes back now to 1986. I've also been a chairman of the serology study groups for both Northern and Southern California, because the CAC tends to divide between North and South, as do many things in California, and that would involve the conventional serology, and I'm also now involved in the DNA study group.
Okay. Is there a CAC ethics committee?
Yes, there is a CAC ethics committee, and I am a member of the ethics committee.
Are you presently taking any courses towards attaining a master's degree?
Yes, I have some unfinished business, as I mentioned earlier, where I was taking my graduate classes, and I never did complete my actual degree. And so I've gone back now to the University of California at Berkeley to complete my master's degree.
How close did you come to obtaining your master's?
Back in 1976, I had all the coursework, but I hadn't finished my thesis when I opted to get married and take a job in Los Angeles.
Okay. And now you're trying to catch up?
Yes.
Okay. How much more work do you think you have before you get the master's?
1 more year.
Have you ever testified in a court of law as an expert in any field of criminalistics?
Yes, I have.
How many times, just generally in the field of criminalistics?
About 100 times.
And what areas have you qualified in?
The areas that I've qualified in initially would be blood alcohol testimony, certainly a lot of forensic serology, trace evidence. I've also testified in paternity blood testing, and more recently it's all been DNA testing.
And can you give us an idea of what types or what jurisdictions you've qualified as an expert in those various fields?
Yes. I went back and counted up, and it's about 27 counties, I believe, in California, maybe more now. I've also testified in the states of Alaska, Arizona, and Nevada, and Washington, and also in U.S. District Court.
Okay. In your capacity with the Department of Justice, how many times have you actually presented testimony in the field of forensic DNA typing?
8, I believe.
What year was the first time you presented expert testimony in that area?
1993, about 2 years ago.
Okay, and your lab provides both PCR and RFLP services, is that right?
That's correct.
Can you give us an idea of whether it was RFLP or PCR in the 8 cases in which you've testified?
I think they all involved PCR, and all but one involved RFLP.
Okay, now, let's talk about some of the areas of expertise or education that you have as they relate to the various components of forensic DNA typing, okay? Have you taken courses in biology and molecular biology over the years that lend themselves to your credentials as an expert in forensic DNA typing?
I've taken classes in molecular biology and also in genetics, and also in recombinant DNA technology to give me the background in the DNA analysis.
Okay, now, would it be fair to break up forensic DNA typing into, just generally speaking, molecular biology and population frequency statistics?
Yes, there are the techniques, and then there are the population, the numbers.
Maybe a kind of a coarser way to break it down is, do these things match? What does the match mean?
Yes.
And the molecular biology and genetics would fall into the first category
Yes, although genetics also falls, of course, into the second category.
as well. Have you taken courses in statistics that lend themselves to your credentials in the field of forensic DNA typing?
Yes, I have, and I've also, as part of my forensic training, statistics is a big part of that in interpreting evidence.
Now, you've mentioned quite frequently the field of conventional serology. Did statistics play an important component in the years before you became a DNA analyst in presenting the meaning of conventional serology results to a jury?
Yes, it did.
How so?
Well, we would just type in different genetic marker systems, and the population would break down into different percentages for those various types. And so we would use that information to come up with an overall statistic as to how common or how rare a certain profile of types was, comparing a blood stain, for example, in a person.
Now, are the population genetics and statistics considerations in conventional serology identical to those issues or those questions in forensic DNA typing?
The foundations are very similar. There is more complexity because of the greater variation that's seen with the DNA typing.
So the molecular biology can help you discriminate more,
Yes, it can.
make the statistical calculations more complicated?
Yes, it can, because of the numbers of types of people and the great amount of what we call polymorphism or typeability of the population. In other words, we can make very discriminating statements using DNA technology that we couldn't make before with just conventional in most cases.
But population genetics and statistics in forensic DNA typing that you've relied on in conventional serology?
Yes.
How many times do you think you've testified in the area of conventional serology?
I would estimate about 60 times, something like that, maybe 70.
In all of the 8 cases in which you presented testimony in the field of forensic DNA typing, did you also present some sort of statistical estimate for whatever results you obtained?
I either presented that or I discussed that process, yes.
Now, you mentioned proficiency testing at different points along the way. I believe with the American Board of Criminalistics, there's a proficiency testing component to it.
Yes, there is coming along now.
Okay. Now, have you yourself, let's separate you from the lab for a minute, have you yourself participated in any sort of proficiency testing program at the Department of Justice?
Yes, I have.
Could you describe that, please?
Yes, the analysts at the California Department of Justice are tested twice a year in proficiency tests. So in other words, we're given what is essentially a mock case twice a year to test and try to determine what sample may have come from whom and that sort of thing.
When you say it's a mock case, does it say mock case on it when you get it?
No, but we know we are being tested, and the types of samples, they give you a scenario. So they tell you this was a blood stain found on so-and-so's car or something like that, and these are the reference samples from a victim and a suspect and a witness or something like that.
So it's not a funny case, it's just a real case, but it's a simulated case.
It's a simulated, that's the right word for it. It's a simulated case.
Are any efforts, what efforts, if you know, are made to actually simulate the case in terms of making up the samples?
Well, sometimes, for example, we'll get samples that are mixtures. For example, we'll get a vaginal swab that is not just fluid from one person, but fluid from two people.
And how many of those have you taken over the years?
I've completed now 5 in the time that we've been doing casework.
Okay, and are the other caseworkers also forced to take these same kind of tests?
Yes, they are.
How many caseworkers do you have now?
Currently, we have 4 plus 2 people that are half-time casework, half-time research.
What about the other employees, the other bench workers, the database people? Do they have to take proficiency tests too?
They do some proficiency testing that is in-house, I believe, but I don't work in that program, so I don't know all the regulations.
Okay, now, so I take it this is all in-house, so somebody in-house scores the test, is that right?
No, the ones that I take are external.
They're
So in other
external.
words, some outside agency provides us with these samples, and they also hold the answers. So the way it has worked in the past is we have to do one that we have no information as to the answers on. The other one may have been, someone may now know the answers because it may be later that you'd actually take that exam. Let me go back and explain that a little bit. What happens with proficiency testing is somebody manufactures the tests. They put together all these tests. Then they send them out nationwide. Now, in our laboratory, we try to meet that. In fact, we do meet that deadline of, say, maybe 3 months later, that we submit results for that particular test. So we don't know, nobody in our laboratory knows what those correct results are. We have to submit them. Now, there are also proficiency tests that we take whereby those samples that came to us, maybe we hold on to them for a certain period of time, maybe even a year, and then the analyst does them blind, but somebody in our laboratory may have access to actually the correct results. And that's just the way proficiency testing works. But we have to do at least one of those where nobody in the lab and nobody, and certainly not the analyst, knows the results. We have to do at least one of those a year, and I think that's now changing with some new legislation, that we might have to do 2 of those a year.
Federal legislation?
I believe so.
Have you ever made a mistake on any of those?
No, I haven't.
Does that mean you can't make a mistake?
No, it doesn't.
Do you try any harder on these because they're mock cases than you do on a real case where life and liberty is at stake?
No, I certainly don't. I approach these proficiencies as just very much like a case, and no.
Okay. And do you know whether or not any of your coworkers have made a mistake on any of their tests?
No, the latest summary that I have on that is that we have, in the laboratory, the caseworkers have now tested something like 135 samples with no mistakes.
Now, this information is routinely made available to both sides in criminal cases, is it?
Yes, through discovery and other processes, we have open books on all these things that defense experts can come and view our test results.
And not only are your conclusions available, but actually all the underlying data upon request or court order?
Yes.
Just from the chronology, your lab was not in existence when these CACLD trials that Selmark testified about were created. Is that true?
That's correct.
Now, the Department of Justice Lab has received accreditation through the American Society of Crime Lab Directors. Is that true?
Yes.
And is proficiency testing a component, or having a proficiency testing program, a component of that accreditation process?
Yes, it is.
When were you accredited?
I believe it's June 1993.
Do you feel that you're any more competent because you got accredited in '93?
No, I don't really feel that, but I think accreditation is important nationwide as a program. I believe in it. I think it's a step again towards enhancing the profession.
Okay, Mr. Sims, did you receive large volumes of samples to test in this case?
Yes, by DNA standards, this would be a very large volume of samples.
Could you explain what you mean by that?
Well, in a typical DNA case, you may have 1 or 2 question stains, and then you may have 2 or 3 or 4 reference samples, and that's the basis for the comparison. And so you usually don't have that much evidence to look at. But in this case, we had a large number of evidence items, something like 61 different items, and then there were sub-items within those, most of those.
And are there records, or strike that, did you receive these items over a period of time,
Yes, we did.
in groups?
Yes, they came in waves.
And are there records that your laboratory maintains to reflect when you received something and to sort of document the intake and outgo of the chain of custody of these things?
Yes, we have a standard form that we used for that.
Your Honor, I'd like to mark as People's 265.
All right,
chain
People's
of custody
265.
records for all of the evidence in this case.
And you've shown those to Mr. Scheck? You've shown those to Mr. Scheck?
I just handed them to him.
All right, proceed.
Could you describe, while Mr. Scheck's looking at those, could you describe how you document just the intake of items?
Yes, we, the standard form is to list the items, describe what purpose it is, and then we document who we received it from, the date and the time, and who in our laboratory received it. That's the standard form. And then, of course, the accompanying information, such as the DNA case number and the relevant information.
Now, were you the lead analyst for all the typing that was to be done in this case?
Yes, I was assigned that position back in August of 1994.
Could you tell us what that means?
Yes, what that means is basically I'm responsible for how the evidence is processed and analyzed in this particular case. I have co-workers, other criminalists that I work with, and specifically in this case I worked with Renee Montgomery and Steve Myers in our laboratory, who both performed analyses independent of me. And then my actual work and their actual work was all put together in several reports where we combined the findings of the various analysts, and then that work is reviewed by a casework supervisor, who in this case was Ken Konzak. So he actually reviewed all these items and all these reports and all these notes before it would go out.
Your Honor, should I write 265 on this?
Yes.
The record reflects it's an 18-page document. Mr. Sims, I'd like to show you People's Exhibit 265 for identification. Would you look at that and see if that reflects the complete intake and outgo of the items that the DOJ had and dispensed in this case?
This is complete, except there was the one additional transmittal for Cellmark to analyze some evidence from the sock blood stain in October.
Now, is that in the form of one of your documents or a letter?
That would be, there would actually be one of these forms, this is called a BFS-4 form. There would be one of those also.
Okay, so we're missing one page.
Yes, we need to come
add
up with that
it.
one
Okay.
page.
I'd like you to look at some boards, Mr. Sims. You previously had an opportunity to look at those. Could we start with 177A? And I want you to re-examine these boards and see if they accurately reflect the items you received and the dates you received them. Sure, why don't you take a second or a minute and look at it.
Mr. Fairtlow, can you get that up just a little more?
Yes, sir.
A little more. Perfect. Thank you.
Just for, as a general question, as you struggle to see those, do you recognize the photos that are in the DOJ column?
Yes, I do.
How do you recognize them?
I recognize them from my initials GAS, my writing on the photos. Some of them appear to be, for example, this one looks like a photo of mine. There is a Polaroid photo of mine that's on each one of these.
Okay, let me know when you've had a chance to ensure that at least for 177A, which goes from 6, LAPD number 6 to 24, that there are items in the DOJ column, they accurately reflect what you received.
Okay.
Okay, 177A is correct as far as what DOJ received?
Yes.
Okay. Could we look at 177B, please? 177B, the photos you recognize
Yes, I do.
accurately reflect the packages that you received on the dates that are on the board?
Yes, I do.
Okay, could we look at 177C, Your Honor?
177C.
Thank you, Your Honor. Are we doing okay, Mr. Sims, on
Yes.
that one?
Yes, I-
Okay, can we look at the
I
next
just
board?
wanted to make sure that
Sure.
I understood that these are the control swatches, and these are the state swatches.
Right, the legend down at the bottom, the blank ones are controls. Your Honor. So 177D is consistent with your records on what you received and when you received it?
Yes.
Okay, why don't we look at 209 then? The same question. Look at the ones that are in the DOJ column. You see that top one a little bit better, Mr. Sims?
I can see it.
See it?
It's only this column that I should be.
Right, wherever DOJ is described.
Okay, so I'm not, this is for LAPDs.
Right.
Yes, this is fine.
That one's fine. We skipped one of the 177 one, 177E. Did you look at that one? 177E is okay? Consistent with your records?
Yes.
Okay, why don't you have a seat for just a minute? Is it common practice in criminalistics for one such as you or any responsible criminalist, when a package is opened, that some sort of initials or date or identifier is placed on the package?
Yes.
Could you explain why that is common practice?
Well, to me, it's part of the chain of evidence that you want to show that you looked at that particular item, and that way when you go back, you can say, yes, that's the item I looked at because there's my initials and case number.
Okay, and that's what you do?
Yes.
And we'll talk about that in this case. I want you to focus just for the moment, we're going to put another board up there, on items 47 and 50. Were those received by the DOJ lab for processing, for DNA typing?
Yes, they were.
What date were they received?
That was on August 12th of 1994.
Okay, and those are drops from the Bundy walkway?
That's my understanding, yes.
Okay, and did you try to conserve evidence each time you sample? We'll talk about your sampling process, but did you try to conserve evidence in every instance where it was possible?
Yes, we did. It's part of our policy with any case, not just this case, but in particular, we were under court order also to be conservative in our approach to this evidence.
Okay, and with respect, specifically with respect to item 47 from the Bundy walk and item 50, the blood drop from the Bundy walk, did you in fact save or conserve evidence?
Yes, I did.
When I say evidence, I mean part of the swatch or swatches.
Yes.
Do you recall, or can you look in your notes to be precise about how much for each of those two items you conserved or you saved?
Yes.
Would you like, I can probably direct your attention to a page, would that help?
Yes.
47, you might check page 18, and 50, you might check page 13 of your notes.
I would just like to point out that we have about 500 pages of notes in this case, so bear with me if I
Okay.
have to find something. I'm sorry, you said page 13 was for item number 50? Is that,
50, I hope it's on page 13, and 47 should be on page 18.
yes, I took about half of item number 50. About half of the material was there I took for our purposes, left the other half. And then the other page was,
When you say the other half, can you be more specific? What did you leave?
I left, excuse me, I left a portion of the swatch.
And you consumed a portion of the swatch in your testing?
Yes,
Okay, and 47, same question.
which is on page,
18?
I think in that one it was about, we took about 2/3, maybe something like that. There were two swatches, and I think we took the larger one.
And your notes actually attempt to reflect the size of what you took and what you set aside or saved?
Yes, I have details as to actually the measurements in terms of millimeters as to what the estimate of the size of each swatch was. And for most of these stain samples, with Dr. Blake, we actually did a weighing of most of these evidence swatches.
When were items 47,
And those are getting close to break time, and may have an application, in fact, the next few questions that he's going to ask.
all right,
Ladies and gentlemen, we're going to take our recess for the morning at this time. Please remember all my admonitions to you. Do not discuss the case amongst yourselves. Don't form any opinions about the case. Don't allow anybody to communicate with you. Don't conduct any deliberations until the matter has been submitted to you. And we'll take a break for 15 minutes, all right? Mr. Sims, you can step down.
Anticipate that the next few questions that Mr. Harmon is going to ask is that he's going to bring out the board, which involves the 47 and 50 being sent out to defense experts and then being sent back, which is something we've already gone into with Greg Matheson. That point's already been established. And I think the court made limiting rulings with respect to that. I don't think it should be brought up again in this context. And one of the reasons that I have particular concerns about that is that we filed a letter yesterday that made more concrete my citation to the County of Los Angeles case, and we still have pending the whole issue of prosecutorial misconduct with respect to attempting to learn about privileged communications concerning those samples and what was done with them. And it seems to me that this testimony is already in, and it shouldn't be brought up again at this time, because depending on how the court rules with respect to that misconduct motion, there are certain remedies involved, and remedies involving this particular prosecutor. So it seems to me that at this point, Mr. Sims has testified as to what he cut. Mr. Mathon has already testified that a portion was taken from these swatches and returned. The chain of custody is complete. There's no objection with respect to that, and there's no reason to trot out this board again, because the only purpose in doing so is an attempt to raise the implication in front of the jury that the defense received samples and did something with them, and the jury's not hearing the full truth about what was done. And it gets us into a whole can of worms that we should avoid.
Right, I take that to be an objection in anticipation. Mr. Harmon, are we about to see that board?
Yes, Your Honor.
All right, let me see the board again.
Okay. I'd like to look at it, and then I'd like to respond to Mr. Scheck, if I could.
Oh, you don't need that. You can just show it to me.
My point is, Your Honor, if you recall, Mr. Matheson already testified to this. And he testified to the initials on the packaging and whose the initials were in a very limited way under a limiting instruction by the court. It was established that swatches were given to Mr. Regal, that some portions of the swatches were taken and then returned. So this is cumulative testimony. And the only reason it's being offered right now is that we had a whole examination through this witness about defense reanalysis and how he had done it, and it's just trying to raise the implication that something was done with these samples and the jury's not hearing about it. And the whole question of what was done and what they know about it and what they don't know about it, should not be raised at this time. This is purely cumulative, and it's done just to raise this other implication. It's already come out through Mr. Matheson. The court's made a ruling on this. There's no reason to do it again.
All right, Mr. Harmon.
Sometimes the truth is a can of worms, and I'm happy that they want the truth to come out, but they don't want this truth to come out, Judge. I love these letters that they keep filing that want to prevent the truth that they got these samples to analyze.
Well, Mr. Harmon, I'm only interested in two things. One, whether it's redundant, since we've already heard Mr. Matheson testify with regards to it, and two, what is the scope of what you intend on asking Mr. Sims about with regards to this
Sure. It's not redundant. Mr. Sims took these pictures, and he will say he will say, I withdraw that Mr. Sims did not take these pictures. They were taken by LAPD. Mr. Sims will say, when I sent them back in October, they didn't have National Medical Services tape on them. They didn't have Kevin Ballard, KD Ballard on them. They didn't have those dates on them. Now, let's not forget something, Your Honor. You ruled way back in February, and they've been trying, because this was a secret at that point that they had gotten these. They've been trying to get you to undo your ruling. Your ruling was prospectively, but it was based on the law, and it was based on sound legal principles, that if you consume or alter our evidence in testing, we are entitled to explain that to the trier of fact. They do not want to allow us, to have you allow us, to explain that to the jury. It's plain and simple. They want to pretend that this never happened. In fact, and we're about to get to this dilemma, when Mr. Sims sent something back tiny, you allowed us to say,
All right, Mr. Farrell, you put that down.
to tell the jury, you allowed us to tell the jury that they consume things in testing. And I guess we're still up in the air about exactly what we're going to tell them. But one of the problems is they've told us in chambers, and I'm not sure if they ever admitted it on the record, but way back when I kept pushing this in January and February, they admitted they consumed half of this tiny sample in testing. And somehow, in order to invoke the legal protection you afforded us in your order of February 8th, we're at that point where we need to explain that to this jury. And they keep talking about sanctions and misconduct about me to prevent, which, you know, whatever happens, happens. I want to utilize the order that was based on sound legal principles. And they want to hold me hostage, which is fine, for my alleged misconduct, and tell the jury that this didn't happen, or pretend that it didn't happen. We're at this point in the trial. We're about to demonstrate that those names and dates were not on there when Mr. Sims sent it back, and they want to stop the whole process. And you know, that's why they filed that other scurrilous letter yesterday about me. So I'll take whatever you dish out in terms of whatever you feel about my conduct, but we're right at a point in this trial where we want to explain that to the jury, Judge.
I believe when the chart was out the last time, you ruled that they couldn't use the word testing or bring out the implication. Mr. Matheson's testimony was limited. It was his lab that took the pictures before and after. His testimony came out about the consumption of the swatch. It's plain from Mr. Harmon's remarks that this is not only cumulative, but he just wants Mr. Sims to say again something about the initials of Kevin Ballard and Karl Zalofka and get us right into the problem that has not yet been resolved. So this adds nothing except he's, I think, just admitting that he wants to do what this court has already ruled he can't do with respect to commenting on testing. And in addition, there is still pending a serious question as to what extent Mr. Harmon has invaded the defense camp and trying to find that out.
That issue is irrelevant to this determination.
Well, no, all that I'm pointing out is that a remedy, if you make a finding. But my point is simply this. It's cumulative. It's already come out through Mr. Matheson. There's no point in bringing it out through this witness except to raise the implication, which this court's ruled already has to be limited.
Mr. Harmon, what do you intend on asking Mr. Sims about this, other than when I packaged it up, sent it back to LAPD, this is the condition it was in, and it didn't have all this other writing on it?
That's it, Your Honor. That's it. He couldn't have testified to that because he didn't send it back from DOJ to LAPD. I mean, this is the point. Matheson did not. I invite them, or I challenge them to show that a full explanation for this is in this record. It's not because Matheson could not testify to that. He can say that's what was on there when it came back, and I'm entitled to prove that's not what was on there when it went out. And that's how I do it through
The thing that I'm worried about, Mr. Harmon, is any implication that testing was done by somebody else. That's what I'm worried about.
Well, Your Honor, you've never addressed your clear language in your order. Now, they want to...
Because it's clear language, I don't have to address it.
Well, we may not have to address it now, and I can't, Mr. Sims can't talk about testing. He can just describe the condition of it. I understand the restrictions, and it would be improper to ask that question or seek to comment on that at this point.
Then we understand each other.
Your Honor, I think that there's no question that Mr. Matheson testified about the initials. He testified it went out to DOJ. You allowed him to testify about the chain of custody without objection. In fact, we spent a lot of time hammering this out with you in chambers. You made a ruling in terms of limiting instruction. You told them, we're going to do it through this witness, we'll put it in this way, we'll get it over with, that'll be it. He just wants to do the same thing again, to bring out these foreign initials. That's all he said he wants to do.
Can you cite me to a point in the record where Mr. Matheson talked about that?
Well, I think if in fact, if you give us a second, I'm sure with the computer we can find it.
See, I think the point is that's how they came back, but I need to prove that that's not how they went out, Your Honor.
I believe that through the evidence custody board itself, they demonstrated it went to
No,
DOJ.
I just want to
came
know,
back.
show me in the record where Matheson talked about the initials of these other people on the envelope. And while we're looking for that, Mr. Harmon, do you have anything else you can go into at this point? I assume so.
Sure.
Cochran? The Sheriff's Department advises me that they were already aware of those signs, already are aware of the locations of those signs.
That's fine. Thank you.
They were ahead of you on that. All right, Mr. Sims, would you resume the witness stand, please? All right, Mr. Harmon, you may resume.
Thank you, Your Honor. Mr. Sims, I think we found the missing page from your chain of custody records. It relates to sending some items to Cellmark.
Yes.
Would that be 265A, Your Honor? It's the missing part of 265.
All right, 265A.
Your Honor, I'll write 265A on the top of it.
Fine, thank you.
Mr. Sims, showing 265, People's 265A, is that the document that was missing from your entire set?
Yes, this was in the earlier discovery packages, why it was missing from the second set. But this documents the transmittal of extracted DNA that I extracted from the SOC number 13 to Cellmark via the DA's office investigator.
Okay, why don't you describe that a little bit? This is DNA that you extracted from a stain that was sent to you from LAPD?
Yes.
And what, go ahead.
As part of my examination of the socks, the pair of socks, item number 13, a stain had been previously cut out. My understanding was that was by the LAPD, Mr. Matheson, and that was part of the package that was sent along with the evidence. And so I took portions of those cutouts, of that cutout, extracted it, ran my tests, and then part of that extract of DNA in the tube I sent to Cellmark for them to test.
What else did you send to them?
I also sent a substrate control from the SOC that Matheson had also cut out. And I also submitted my extraction reagent blank that I extracted along with those samples.
And why did you send that reagent blank along with the samples?
Well, that was part of the extraction set. I always extract a reagent blank along with the stains and the substrate control samples. And I wanted them to have that, so if they wanted to do any PCR analysis, they would have an extraction blank. That's important for PCR.
Okay, we'll talk about that probably
Yes.
this afternoon. When did you send 13, or that stain and the substrate control and the reagent blank?
Those extracts were sent on October 19th, 1994.
Okay, now the boards that you looked at merely reflected items that you had received directly from the LAPD, is that correct?
That's correct.
Okay, and was there, or has there been an exchange of items between you and Cellmark on occasion?
Yes, there was one occasion when I received some samples from Cellmark, and then there was another occasion besides this when I sent samples to Cellmark.
Okay. Just a bit of background here. When you receive items, they had the LAPD item numbers on them?
Yes, they did.
And does the DOJ assign separate item numbers to them?
Yes, we do. We give each item our own number.
And the set of documents numbered People 265 for identification, those reflect both the LAPD item numbers and your numbers. Is that correct?
Yes, they do. The only exception was some of the exemplar samples just had the name of the person, the coroner's case number, for example.
Okay, and those are reflected that way in People's 265 for identification?
Yes, they are.
Okay, other than the stain from the sock that you sent to Cellmark, what other items did you either receive from Cellmark or sent to Cellmark? And if you would please use the LAPD item numbers.
Yes. The item numbers were as follows, and I received these actually via Mike Stevens of the District Attorney's Office. He was the messenger for these items coming from Cellmark to us. The item numbers were item number 49.
Okay, that's one of the drops on the Bundy Walkway
That's my understanding, yes. And then
Okay.
item number 52, another drop.
from Bundy.
That's my understanding, yes.
Okay. What else?
Those were the two items that we received from Cellmark, and then the other thing that involved Cellmark, or the other shipment, was, and I should give you a date for those two items, 49 and 52. That was received by us on October 13th of 94.
Okay.
Then on February 16th of 1995, February 16th, we sent to Cellmark via the DA's office investigator, Dana Thompson, extracted DNA from I can give you our numbers. I'll hold off a second and I'll give you the LAPD numbers. LAPD number 29, LAPD number 29 control.
Now, that's the steering wheel drop.
That's the steering wheel, yes.
Okay.
And then also items from the fingernail scrapings.
Those are
From Nicole Brown.
Are those LAPD 84A and B?
Yes, they are.
Okay.
And then also another extraction reagent blank was sent out.
Okay, did you ever receive LAPD item number 48, another Bundy Walkway drop?
Yes, I did.
When was that?
That was received on August 12th, 1994.
And did you send that somewhere else as well?
This is number 48 now.
Yeah.
That particular sample was sent back on October 11th.
Okay. Did you also send numerous or several items to the FBI?
Yes, I did send items to the FBI.
And when did you do that, and what were those items?
There were two items that were submitted to again, this was to DA's investigator Dana Thompson. This was on February 16th, 1995 for transmittal to the FBI. One of those was a heavily blood-stained area from item number 86, the dress of Nicole Brown. And then a relatively unstained area from the dress also was sent.
Anything else?
Those are the actual samples that I sent out to the FBI. I believe there were some others that went via LAPD.
Okay. Now, in a while, probably this afternoon, we're going to discuss the testing methods that you used and the results of your analyses. But is it true that some of the samples, of the many samples that you received, some were not typed?
That's true.
And of the ones that were not typed, were there even some that were never even opened?
Yes, there were about 10 items that we did not examine.
Okay, and there were a few that produced no results, is that true?
Yes, that's true.
And if it's okay with you, we're only going to discuss the results later on today.
That's fine.
Okay. You've described your role as the lead analyst in this case, and you mentioned a couple of other people that worked with you, Steve Myers and Renee Montgomery.
Yes.
Are there actually others that performed routine tasks in the typing process that we'll be hearing about in a while?
Yes. For example, we have a staff of people that do what we call batch probing, whereby these RFLP membranes are actually probed with the various DNA RFLP probes, and they actually perform that part of the analysis themselves. And then I'm the one that develops the films.
Now, where do they stand in the pecking order at DOJ?
Well, they're all part of our team. Some of them are criminalists and some of them are technicians.
Okay. Could you, before we get into some of these results, could you just describe the items by number and description of items that were never tested by DOJ lab?
Yes, I can do that. Excuse me. I have that summarized on my my last report, which is dated April 6, 1995. The items that were never examined were item number 49 control, item number...
That's a substrate control.
That's a substrate control.
And why was that never tested?
Because we didn't do any typing on item number 49.
Okay.
So we didn't have any need for the substrate control for that.
Why no typing on 49?
Item number 49 gave us a very low level of human DNA to work with. And rather than consume the additional sample that was available to us in the form of the swatches, we just decided to let that one go and preserve the swatches.
Okay. Go ahead through your list.
Okay. Item number 4.
And item number 4 is one of the stains from Rockingham?
Yes.
Okay. Why was that never tested?
Well, we did some testing on one of the stains from Rockingham, but we didn't feel that was that critical to test the other stains.
Well, I guess that gives rise to a question. Is it important to have some background information about a case in deciding which samples to test and which not to test?
Yes, I think so.
And based on the information that was provided to you about the location of stains at Rockingham, is that why you didn't test for?
Yes.
What information did you have?
It is hearsay
It's not offered for the truth of the matter, no?
for a limited purpose.
Yes, of explaining why he didn't do any typing on it. No, it's...
Sorry, it's also a question who's making the decisions.
I'll withdraw the question.
Proceed.
Were you aware of other test results and the location of that stain when you decided not to test number 4?
Yes.
And taking those things into consideration, is that a reason or the primary reason you didn't test number 4?
Yes.
Have you heard the term representative sampling?
Yes, I have.
And did that contribute to your decision not to test number 4?
Yes, that and that there were other things that we felt were more important to test
At that location?
at that location and with regards to this case.
Okay, what other stains did you not test?
Item number 5.
Okay, and is that in the same category as number 4, the reason it wasn't tested?
Yes,
It's another Rockingham stain.
yes.
Next item you did not test,
Item number 8,
and is that another Rockingham stain that fell into the category of 4 and 5?
yes,
And that's why you did not test it?
yes.
Next item.
Item number 12,
Okay, and what information did you have about that that made you decide not to test it?
my understanding,
Sustained.
Were you aware of Cellmark's results when you made the decision not to test it?
yes.
And, okay. What other item?
Item number 21,
And that's one of the stains from the Bronco?
yeah, it was from the, yes, it was from the Bronco driver's door interior.
And why did you not test that stain?
We had tested several other stains in the Bronco.
And is the representative sample, did that play a role in your decision?
Yes, that's part of it.
What other items did you not test?
Item 22, a similar stain from the Bronco.